It is not on the agenda that the United States will join the International Criminal Court. But the International Criminal Court can become more threatening, which is what this conference that's going to open next week is about. This is the first review conference since the court was launched in 2002, and the main item on the agenda is to fill in a blank which was left in the initial statute of the court, which referred to the crime of aggression and then just put in brackets to be defined later. They now propose to fill in the blank. There has been a working group of several countries working on this, very tellingly headed by Liechtenstein. In 1919, Liechtenstein applied to join the League of Nations, and the League of Nations, which wasn't such a serious organization, said, come on, we're too serious to have Liechtenstein as a member because you don't have an army, you don't even have a post office. No, come on, cut it out. Now, the International Criminal Court proposes to have this group led by Liechtenstein define aggression. This is really central, I suppose, to the whole, not just to international law, to the whole understanding of the international system. The definition that the working group has proposed tracks General Assembly resolutions from the 1970s. Among other things, it stipulates that only a state can be guilty of aggression. And it includes within the definition of aggression not just a land invasion in which you hold on to someone else's territory, but a bombardment, even just a few cruise missiles, blockade, other kinds of short-term and minimal, let's call them interference. Since only a state can be guilty of aggression, it seems to follow that you do not have a right of self-defense against a non-state. And there's no provision in the definition for anything like self-defense, let alone preemptive response to a gathering threat. What they are still uncertain about is should there be some trigger for this, and what they've put out as options. Maybe there could be prosecution only if the Security Council approves. Maybe there could be prosecution only if the General Assembly approves. Maybe there could be prosecution only if the International Court of Justice approves. Or maybe there could be prosecution if the trial chamber of the International Criminal Court itself approves. Very unclear what's going to come out of this meeting. It's going to start next week, run through June. Britain, France, Japan, Canada, Australia, let's call them the grown-up countries, have said, no, come on, this is no. This should be left to the Security Council. If you do not require Security Council approval for a prosecution, you are changing the UN Charter. Right? The UN Charter left all the serious questions to the Security Council, and of course on the Security Council the permanent members have a veto. Britain and France, being permanent members, think that's a good system and should be preserved. Interestingly, they haven't been able to persuade the EU or even a sizable number of EU countries to go along with this, so everything is up for grabs. I have heard from people who actually had done a tour of Europe talking to people in European foreign ministries. They're just not focusing on this because they don't see that it's all that important. And the Obama administration hasn't done much to draw their attention to it. One of the things that's most amazing is that going into this conference, the United States doesn't have a public position. We've announced that we're attending. There've been some talk about Hillary Clinton may go, maybe she won't go, but we'll send someone there as an observer. But we haven't laid down a marker. In one way, you might think that that's, well, we're not a party, so who are we to lay down a marker? But actually, our position on this has been changing. If you remember, in Bush's first term, we were really pretty aggressive in trying to contain the International Criminal Court. We passed this, well, first you remember President Bush unsigned President Clinton's signature saying in principle we'd like to join, although even Clinton said we wouldn't ratify it. But Bush took away the signature, and then we passed the American Service Members Protection Act, which said that the United States wouldn't give any assistance to the court. We negotiated over 100 bilateral agreements with individual countries saying you won't and we won't send anyone to the court. We won't honor extradition requests from the court. In Bush's second term, he really backed away from that, and in a number of areas he made gestures of cooperation, most notably our UN representative, I guess it was still John Bolton, abstained when the Security Council was asked to authorize prosecution in Sudan, which hadn't joined the International Criminal Court. So to give jurisdiction, you needed Security Council approval. And we made a show of, okay, we won't stand in the way, we will cooperate. And we stopped criticizing the court, and we made some polite speeches. Under Obama, there have been more polite speeches. Hillary Clinton has said it's a really important institution and we really want to cooperate. So as the Reverend Wright used to say, the chickens are coming home to roost. I think this could be extremely bad. It will take a long time, even if the gathering in June does decide on the worst definition and does decide that the ICC on its own should be allowed to prosecute. It will take a long time for enough countries to ratify for this jurisdiction to be added. There'll be time to have a lot of debate. There's probably not time left to change the administration's position or for the administration even to come up with a position. I was told that Harold Koh was going around to European capitals saying, we're the Obama administration. Give us a break. We're not like Bush. And that was not enough of an argument, surprisingly. Still, I think, although it'll take a while for this to be added to the court's jurisdiction, and maybe it won't happen, it's, I think, quite important. And we're coming very quickly to a fork in the road. There are two ways of playing this. The Obama team seems to be falling back on the idea that we should be a kind of good sport, team player, show that we're not trying to undermine the court, and then responsible countries will steer it in a more responsible direction. The other way of doing it, which I think is more promising, is to say we regard this as extremely threatening. And we will go back to not just resisting the court, but doing everything we can to undermine it. And let me just, before I stop, say why I think there's a lot at stake. It's not that we really can envision a world in which no one does anything wrong because they fear the International Criminal Court. That's just preposterous. There will always be countries that don't fear the International Criminal Court, which after all can't arrest anyone. It relies on cooperation, and it won't get it from rogue states anyway. But it can inhibit, I think, even countries that do use force. I think for sure Israel will hesitate before it does something like the attack that it did 2 years ago in Syria on their nuclear facility. They might do it anyway if they feel that they absolutely must, but they'll hesitate more because it will be easier to have immediately an international investigation and promise of international prosecution, which is intimidating, embarrassing. I'm not confident the people in the Pentagon have the total kind of resolution to say, damn the prosecutors, full speed ahead. It's intimidating to be told that you personally might be prosecuted. And what's true in the Pentagon is more true, I think, in the White House. What's most true is that our sometime allies are bound to be very intimidated by this. We had a sizable coalition going into Iraq. There's been a lot of hand-wringing afterwards. It looks a little bit worrisome if you're a British prime minister to go through what Tony Blair went through and all the recriminations. It looks a lot more intimidating if you think there's an international prosecutor who will say you are personally guilty of aggression and should stand trial in The Hague. Even if they don't go through with it, even if you're not extradited, it's really intimidating. So I think we have to look forward to a world, if this is set up, in which we don't have many allies when we're trying to put together a coalition, in which even people in the White House are hesitant. Conversely, you have to think this will embolden the bad guys. I mentioned at the beginning, I want to come back to this. The crime of aggression as defined, as they propose to define it, the working group, applies only to states, not to terror networks, not to guerrilla organizations. And that isn't an inadvertent oversight. Fundamentally, that goes back to the 1970s, which was the General Assembly majority's view of the world, which is if you are sponsoring guerrillas, that's just war of liberation. That's just what you can do as a third world country. That's not something that should justify a response from a fully armed state with air power and sea power. If we buy into this, we are basically encouraging Iran and other bad actors to sponsor terror attacks and then say, oh, well, it just happened. You can't blame us. So that will make the world a more dangerous place. And it makes the world a more dangerous place even if, which I stipulate, this is not really going to be a world in which everybody looks to the International Criminal Court for guidance. But it can make everybody more unsure, except for the people who we want to make more unsure. And as I said, I think the time is running out for us to lay down a marker and say to countries that are wavering, this is really, really important to us. Why is the Obama administration not saying loudly and emphatically, this is really, really important to us, cut it out? I think they're not sure that it's really, really important to us, and that's pretty worrisome in itself. So, questions? I think to worry about our joining up is not, it requires 2/3 of the Senate. It's really hard to get 2/3 of the Senate. In a way, this is what I meant when I said it would be optimistic. It'd be great if the Obama administration said, all right, let's just up or down, let's just come to a vote. Because they wouldn't get a majority, let alone 2/3. And it'd be really good, we could have this over with, it'd be absolutely clear, no, not even with the largest Democratic majority since whatever is the last time we had this, decades ago. You cannot get this through. You're not going to get this through. That'd be good to establish, but they won't do that. What they're doing instead is saying, whoa, we can't join now, but we'd like to cooperate. I have to say I'm surprised that there hasn't been more writing about this. I kind of hung back because I thought, well, other people will rush forward and say things, and everybody has been in the same daze. It just seems, it seems so fantastical that this conference in Uganda is now going to rewrite the UN Charter, which is literally what this would mean. Right? Instead of the great powers of 1945 having a veto, we would determine who gets to use force when on a cross-section of the General Assembly meeting in The Hague. This seems just utterly fantastical. Could this really happen? And it's more amazing that it hasn't provoked more debate in Washington. But people, I mean, I want to put it on everyone's agenda, pay attention to this. I think at some point it will be helpful, some point soon, for people in Washington to make a lot of noise. This is one of those situations where I think being in the opposition doesn't prevent you from making a difference, because you want to convey to the world that America is actually not ready to cooperate, not even a little bit. It's just totally out of the question as far as we're concerned to have lawyers in The Hague deciding when we can use force and when we can't. Lawyers in The Hague defining what is our permissible right of self-defense. The Charter, the UN Charter, says there's an inherent right to self-defense, and what we're talking about is who defines what that is. And our assumption has always been, well, we have to decide for ourselves. That's what it is to be a sovereign state. And the very explicit premise of this project is, no, that's unfair, because the United States has a fleet and cruise missiles and other things which most of the world doesn't. So it should be defined by legal process in The Hague. That's a total transformation of the world. If we are not willing to say in a loud, emphatic way, absolutely not no, really we're not willing to defend ourselves. Yes, so here's the definition that they propose. after you get through various other items like bombardment and blockade and attack, use of armed forces, then the last one is the sending by or on behalf of a state of armed bands, groups, irregulars, or mercenaries which carry out acts of armed force against another state. And the question is, can you view Hezbollah as being sent by or on behalf of Lebanon? I don't think so. Lebanon has no say at all in what Hezbollah does. And if you tell me, oh yes, but Hezbollah is now in the cabinet, that's not Lebanon having a say over Hezbollah, that's Hezbollah having a say over Lebanon, which is different. Maybe you could say, but Iran is really pulling the strings, which I think is plausible. But I don't know even if I would say, but it certainly wouldn't be clear to everyone that anything done by Hezbollah is clearly, juridically, an act of the government of Iran. So at least this is very shady. Whereas the response to Hezbollah, anything that we did that involved, or Israel, that involved force, you could readily say, you sent cruise missiles, you bombed them, you even blockaded them, that's an act of force. There's this asymmetry that the state, when a state acts, it's very clear. When a non-state actor acts, there's all this fuzziness, which Iran and Lebanon and everybody understands. You preserve a little bit of deniability by saying, well, it just happened. So even in terms of definitions, I think they did not set this up to be reassuring. And always you have to remind yourself it's not a matter of definitions, it's a matter of what do you imagine the prosecutor in The Hague is likely to think his job is. Let me mention two things which I haven't mentioned. After the, start with Afghanistan. It's now been more than a year that the prosecutor says he's been looking into allegations that NATO forces in Afghanistan have committed war crimes and should be prosecuted. More than a year of looking into it is really saying, I don't want you guys to be feeling confident. I mean, this is something you would think he could have resolved in less than a year. Meanwhile, there was a petition from the PLO saying, or whatever they are, the Palestinian Authority saying, or maybe it was just the Hamas government in Gaza, actually, saying war crimes are committed by the IDF and they should be prosecuted. And it's absolutely clear under the statute of the International Criminal Court, it has jurisdiction only involving states that have ratified or crimes that took place on the territory of states that have ratified. Israel hasn't ratified. Gaza is not a state. Palestine is not a state. It's not recognized by anybody as a state. And the Hamas government said, well, but we're like willing to ratify, so you could treat us as if. Now, this is pretty open and shut. They should have been able to say after one day, all right, cut it out. No, we don't have jurisdiction. Again, more than a year has gone by, and they say, well, we're considering it, which says to me they don't want to disappoint some of their constituents. I'm not saying they will do it. I think probably they won't do it, but that they've taken so long to decide reminds you that there's a lot of political pressure on the ICC prosecutor to be, quote, even-handed. So far, he's had 4 cases. They're all in Africa. And all the African governments complaining, saying, well, how come you're just picking on Africa? How come you don't go after Afghanistan? What about NATO in Afghanistan? So I think there'll be a lot of pressure. I mean, it will be, what's the electorate for the ICC prosecutor? It's basically the UN General Assembly. It's not quite as large as that, but it's now more than 100 countries. It's getting close to being almost a cross-section of the General Assembly. Most of them are not our friends. Some of them that are our friends don't act like they're our friends when it comes to questions of international justice as they see it. So the idea that this prosecutor is going to be, from our point of view, make reliable judgments seems not a real good bet. Yeah, Deborah.
What are the chances that they go to this conference and come out without a working definition of aggression?
It's as likely as not that they'll say this needs more study and let's come back in 6 months. So I don't think this is all going to be over in June, but I mean, they do have proposals on the table. They could vote them. One of the great things, it just shows you like how fantastical this is. One of the proposals is they should only have jurisdiction when a country agrees to submit to the jurisdiction of the court on this crime of aggression. So you have to imagine a country being willing to go to war and then saying, you know what, you ought to prosecute our leaders. This was a terrible mistake. Now, I guess that's not out of the question if there's been a revolution intervening, but I don't really see how the ICC is able to produce the revolution. So, yeah, there is something just fantastical about it. And what does that tell you? I mean, let's go just one notch up from simple-minded, just like basic, obvious. This is not a very reliable way of stopping aggression. What it is a tool to embarrass governments. Who's going to be embarrassed? I can tell you right now, North Korea cannot be embarrassed. I can tell you right now, Iran cannot be embarrassed. Who could be embarrassed? Well, you know, people who run for re-election. I mean, of course, this is a tool that's more effective against democratic governments. And I don't think anybody is missing that.